Hello, the case I'll be presenting today is Methanex Corporation against USA on the North America Free Trade Agreement Tribunal. We should begin with the facts. Methanex Corporation is a Canadian company that supplies, distributes and markets methanol all over the world, and also it is the main supplier of methanol of USA. The key component of its product is MTBE, which is used to increase oxygen content and act as an octane enhancer in unleaded gasoline. The second fact is that the state of California ordered to ban the use of MTBE by the end of 2002. California argued that banning MTBE was necessary because this additive was contaminating drinking water supplies and was therefore posing a significant risk to human health, safety, and the environment. Methanex were clearly affected by this ban, so they began a process on the NFTA tribunal against USA, and they were seeking for almost $1 billion in compensation from the United States. They argued that the ban is a tantamount to an expropriation of the company's investment and thus a violation of the NFTA's Article 1110 enacted breach of the national treatment obligation in Article 1102 and was also in breach of the minimum international standard of treatment obligation in Article 1105. In addition to this, they also allege that California's government was corrupt to subvert the ethanol market, that is the competence of methanol. But in conclusion, this case was an investment dispute based on provision contained in Chapter 11 based on investment. Now I will present the main topics of the tribunal decision. The first is the national treatment ruling. The national treatment part of the ruling is one of the three key rulings on the substantive provisions of NFTA's Chapter 11. The main aspect of this ruling is the tightness that it approaches the key test of in like circumstances. Like the tribunal said, under most national treatment obligation, host state must treat foreign investors no less favorably than a domestic investors in like circumstances. In this case, Methanex requests to have the tribunal adopt a very broad economic sector reading of this requirement, arguing that the economic competition or sector approach of the like product analysis in trade law should be applied here. The tribunal made it clear that the like circumstances test require compare the foreign investor to those most closely comparable in the domestic sphere. In this case, Methanex as a manufacturer of methanol had to be compared to other US-based manufacturers of methanol, all in identical circumstances to Methanex. This ruling approaches the comparative requirement from a basic common sense point of view, rather than seeking complicated legal rationalization that were to overstand the comparison, like Methanex wanted to do. The second topic of this case is the minimum international standard rulings. Regarding this topic, the tribunal answered the question of whether discriminatory conduct by a host state based on a foreign nationality of an investor is a breach of the minimum international standard obligations. It appears to have ruled that this wasn't prohibited conduct under international law, in absence of other aggravating factors that might elevate the discrimination to a breach of international law. This ruling should help clarify legal reality that non-discrimination is a treaty law construct in this area, nor a customary international law one. Now, the main argument of this case is its expropriation ruling. Methanex claimed that regulatory ban of MTBE is a measure tantamount to an expropriation, prohibited in Article 1110. Therefore, the economic impact of the measure on Methanex require a compensation. In this case, the tribunal said that regulations are not expropriations unless specific commitments had been given by the regulating government to the putative foreign investor, contemplating investment that the government will refrain from such regulation. Assuming a full and literal application of the caveat, the same circumstances will be subject to a breach of contracts proceeding in a variety of international or domestic processes, so adding an expropriation recourse likely change little in practice. So we can notice the importance of any undertaking a host government gives to a putative investor when key decisions about the viability of an investment are being made. To that extent, it may usefully serve to heighten the awareness of government officials of the importance to their undertakings and the consequences they may have. The tribunal also makes one additional point of importance. This is the exclusion of trading goods as an investment in itself, like previous NFTA cases have suggested. Thus, loss of market share even through foreign-based trade could be the basis for an investor-state arbitration under this approach. The Methanex Tribunal rightly questioned this broad approach, applying a more limited and appropriate view that market share may be part of the assets of an investment and may have an impact in calculation of damage for a breach of an obligation, but that not itself for an investment. Therefore, the final decision took by the tribunal assessed all costs against Methanex in this case and rejected the claim. And finally, we got the corruption argument. In this part, the methodology adopted by the tribunal has two hallmarks. The first is the use of logical inference and the self-labeled connected dots approach to the evidence. The tribunal expressly recognized that it has the capacity, in the face of circumstances where clear evidence may not be available, to draw logical inferences from the evidence that was adduced. The second element are the national and international and legal acts. The tribunal made it clear that these acts could be the base of finding corruption. This is important for the potential application of this approach to allegation of corruption by investor of host government official to achieve benefits relating to an investment. In short, this decision lays out the tools for arguing that when an investor in an arbitration seeks to rely upon the fruits of its own corrupt activities, the jurisdiction of the tribunal to hear that case can be vitiated.